Welcome to Law Days and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Law Days and Lattes. Hello, everyone. Welcome back to Law Days and Lattes. I'm your host, Sidney Whelan. This podcast is sponsored by the Whelan Law Firm of Moberly, Missouri, your go-to source for legal issues encountered by your family and your business. Today, we're talking about one of the most important legal tools you may ever create, the durable power of attorney. It's not the most glamorous topic, but trust me, it's one that could save you and your loved ones a lot of heartache in the future. Whether you're planning for your own future or supporting someone else through this process, this episode will break it down for you. Let's get started. What is a durable power of attorney? Let's start with the basics. A durable power of attorney, or DPOA for short, is a legal document that gives a chosen person, known as your agent, the authority to act on your behalf. The durable part means that this document remains effective even if you become incapacitated and unable to make decisions for yourself. You might wonder, why not just use a regular power of attorney? Well, those documents typically end if you become incapacitated, which is exactly when you might need help the most. A durable power of attorney bridges that gap. DPOAs can cover a wide range of responsibilities, from managing your finances to making healthcare decisions. The beauty of this document is its flexibility. You decide how much or how little power your agent has, but we'll get into the details of that shortly. Now, let's talk about the person you're giving this power to, your agent, or attorney-in-fact. Choosing the right person is key because this role comes with serious responsibilities. Your agent might handle financial matters like paying your bills, managing your bank accounts, or even selling property if needed. If you have a healthcare DPOA, they might make medical decisions on your behalf, from choosing treatments to managing end-of-life care. A medical DPOA allows you to include a healthcare directive, letting your medical providers and your agents know what your preferences are for serious injuries or illness or end-of-life care. Now, maybe you haven't given this much thought up until now, or maybe you have. This is the place to have the discussion with your attorney to make sure your wishes are documented. As an estate planning attorney, I know that there are many different thoughts on end-of-life medical care planning. Most of my clients do not want to be kept on life support indefinitely. Some of my clients want "do not resuscitate" language in the medical DPOA. And if that is your wish, be sure to include that language in your durable power of attorney. I've had some clients be very specific about the type of care they do or do not wish, and some clients prefer to give more general directions, but leave it up to their loved ones to make the best decision or choice at the time. Because of the potential scope of authority, it's critical to choose someone you trust completely to act as your agent, someone who understands your values and will act in your best interests. Keep in mind, though, that an agent's power is not unlimited. They're legally required to act in your best interests and according to the instructions you outline in your durable power of attorney. So, why is a durable power of attorney so important, you may ask? Well, imagine this. You're in an accident and unable to make decisions. Without a DPOA in place, your family may have to go through a lengthy and expensive court process to get permission to manage your affairs for you. Or think about your aging parents who may eventually struggle with dementia or Alzheimer's disease. A durable power of attorney allows a trusted family member to step in and handle things like medical care and finances. Without a DPOA, the court may have to appoint a guardian or conservator. While this might sound like a solution, it can be a complicated and lengthy process, and the person the court appoints may not necessarily be who you would have chosen. So, how do you set up a durable power of attorney? It doesn't have to be overwhelming. Here's how to get started. First, decide what kind of durable power of attorney that you need. A financial DPOA gives your agent authority over your finances, while a healthcare DPOA focuses on medical decisions. You can also combine both, especially if the person you wish to name as your agent for business purposes is the same person you would choose to help you with medical decisions. Second, as we said before, choose your agent wisely. This person should be trustworthy, organized, and willing to take on the responsibility. If you have any reservations about someone you were about to name as your agent, perhaps you should reconsider. Next, the document must be carefully drafted to your specifications. I suggest that you work with an attorney to make sure it complies with your wishes and your state's laws. Be sure to specify exactly what powers you're giving your agent and when those powers may go into effect. Finally, execute the document properly. Most states, including Missouri, require the DPOA to be signed in front of witnesses or a notary. Once it's done, keep the original in a safe place and share copies with your agent and other relevant parties. Now, let's clear up some common misconceptions about durable powers of attorney. First, some people worry that a DPOA gives the agent too much control. But remember, your agent can only act within the scope you outline in the document. You are in charge of defining their powers. Second, a DPOA doesn't mean you're giving up control of your life. As long as you're capable of making decisions, your agent can't override your wishes. Another common question is whether a DPOA can be revoked. The answer is yes. As long as you're mentally competent, you can revoke or change your DPOA at any time. For most purposes, a DPOA ceases to have any effect once a person dies. However, there is one exception. Did you know that you can appoint someone to make your funeral and burial decisions in a DPOA? And you can leave specific instructions on the type of funeral and burial that you would prefer. Finally, some people think creating a DPOA is expensive or complicated. It's not, even if you use the services of an attorney. Before we wrap up, let's talk about something called springing powers in a durable power of attorney. A springing power of attorney is a type of DPOA that springs into effect only under specific conditions, typically when the principal, you, becomes incapacitated. This option can be appealing if you're uncomfortable with giving someone immediate authority over your affairs. With a springing durable power of attorney, your agent can only act once a predefined event happens, like a doctor certifying that you are no longer able to make your own decisions. However, while springing powers can offer peace of mind, they can also create complications. For instance, determining incapacitation can take time and might require a formal evaluation or multiple medical opinions. During this delay, critical decisions could go unaddressed. So it's important to weigh the pros and cons. If you trust your agent completely, a non-springing DPOA that takes effect immediately might be simpler and more practical. On the other hand, if you want to maintain full control until absolutely necessary, a springing DPOA could be the right choice for you. Be sure to discuss this option with your attorney to determine what makes the most sense based on your own circumstances and preferences. Once you have your durable power of attorney, what do you do with it? Well, I suggest giving a copy to anyone you have named as an agent and make sure they understand your wishes if they have to act under the DPOA in the future. Next, I would make sure that your medical providers have a copy of it in your file. This is particularly important if you're hospitalized. In my opinion, I would much prefer that you provide them with a DPOA that has been carefully drafted with your preferences and not a generic durable power of attorney that someone asks you to sign at the last minute when you may not be feeling up to the task and may not be able to make the best decisions. Well, that's it for today's episode. A durable power of attorney is one of the most important legal tools you can have in your planning toolkit. It ensures that no matter what happens, someone you trust has the authority to act in your best interest. If you haven't set up a DPOA yet, I encourage you to start the process today. And if you know someone who might benefit from this episode, share it with them. It can make all the difference in how they plan for their future. If you enjoyed today's episode and want to stay updated on similar topics, please subscribe to Law Days and Lattes on your favorite podcast platform. And please, while you're at it, check out our Law Days and Lattes podcast pages on Facebook and Instagram. Our goal is to create a space where we can learn from each other and grow together. So, we want to hear from you. Share your thoughts and ask questions. We will put all of the links in our show notes. Thanks for listening. And as always, my friends, grab your favorite latte, hold your loved ones tight, and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.